listened to all your statements, each one of them. And I'm truly sorry to everyone I've hurt. Thank you, Your Honor.
All right, welcome back to Law&Crime Report. I'm your host, Bob Bianchi. There you had Joseph D'Angelo, also known as the Golden State Killer, as he's speaking to the judge at sentencing. He has now arrived in state prison. It's going to be a fascinating case. We've got a fascinating show, a lot of great topics. So we're going to start with this one. Let's listen to the prosecutor, Anne-Marie Schubert, who had statements to make that was during and after the sentencing. And as you can imagine, there's been a lot of controversy about some of what prosecutors did here. We'll discuss that with our guests going forward, but let's take a listen.
Certain are we that he stopped committing these crimes in the late 80s? And if he did stop them, can you offer any insight as to how someone like that might have been able to stop them? And did it bleed out and did it push out in other ways in his life? You know, since then, were there other signs? I'm just curious what your insight is.
I think I tried to answer that earlier. I don't think we'll ever know. I mean, honestly, on the day of his arrest, I got a text message from a colleague of a Wikipedia article about when did forensic DNA come into existence, and it coincidentally was 1986. And so, the question needs to be posed to Mr. D'Angelo.
The items that were taken from his home, could you speak to what those items were and if any of those were ever returned to some of the victims or survivors, if they belonged to them?
I don't think I can speak to those. I don't think so. I don't know about Amy or Tin or any of the other prosecutors, but I don't think it's, at this point, I don't believe the arrest warrant or the search warrants have been unsealed from the court, so I don't think it would be appropriate to comment at this point. Maybe someday, though.
Now, there were multiple prosecutors involved in this case. These were killings that spanned over a significant period of time and then just seemed to have stopped. And you guys may recall this case. It's based on some genetic testing that eventually got him. They got the DNA from D'Angelo, who was a suspect. They ran it into Match GED, which connected familial lines of DNA and ultimately narrowed him down as a suspect and brought the case against him. Let me bring in one of our awesome guests here, John Delatorre, Dr. John Delatorre, psychologist out of Arizona and Texas, does forensic evaluations and risk and threat assessments, and is a TV legal analyst. Dr. John, welcome to the show, sir.
Thank you very much, Bob.
Yeah, so I think I've asked this question of you perhaps before, but it bears repeating. They took this case out of the death penalty and gave him a life sentence as part of a plea agreement. For closure for the family, to ensure that there weren't other victims. I don't understand. This is not the only case that we've covered. Chris Watts was another case we covered. Why prosecutors don't demand that these people be fully debriefed so that they can at least give the family some sense of an understanding, and moreover, if other victims were at play. What are your thoughts?
I think sometimes it's probably more about closing the cases that the prosecutor can close, and not so much the emotional closure of any of the potential victims. And even if the prosecutor decided that the emotional closure was important, there's no guarantee that the victims would have that emotional closure. I think it's very complicated when someone has a trauma and how they're going to move past it. So I think sometimes prosecutors take the emotion out of it and just focus on closing the cases that they know they can close.
Well, Doc, let me ask you something, because I've handled serial murder cases before. He's going to go in. Personally, yours truly would have required that, or certainly have attempted to have acquired that information. You never know, because there are times people go into the jail and then later decide to speak about other murders. We've seen this on a number of occasions. Based upon, and I know you haven't evaluated Joseph D'Angelo, but based upon what you see with these serial killers and that desire he had for attention by repeating, victimizing the people by victims by calling them on the phone and toying with law enforcement, do we expect we're going to hear from him again in state prison because he just wants to be at the center of attention?
I think so. I think the question that the prosecutor was asked was, why did he stop? I think that's an important one because generally speaking, they don't stop unless they're caught or somehow something gets in their way. So there were things that he was doing that may not have been serial murder, but there was some way that he was alleviating the emotional stress by not doing those crimes that he had done before. So I wouldn't be surprised if he comes around and starts talking about how maybe he wants to get lesser time, so then he's going to um, reveal more victims over the course of his life in conjunction with less time that he has to serve.
One of the things, doctor, that you do is forensic evaluations of individuals and do risk and threat assessment. Can you give us some insight into the mind of a person like Joseph DeAngelo? What makes them do such horrific and horrible crimes?
Sometimes it's about their upbringing. Sometimes it's about all of the emotional trauma, physical trauma, sexual trauma that they've experienced. But sometimes it's not about that stuff. Sometimes it's just there's a personality structure where power and control are seen as priorities over other things. And so they'll try to find ways of compensating those feelings, those need feelings of power and control. I think sometimes it's about domination. And D'Angelo's behavior suggests someone who needs power, needs to feel in control. I mean, he was a police officer. That's one example of exercising that power and control need. The crimes that he committed and the ways in which he committed those crimes, they're all about his need to dominate. And so that has nothing to do with whether or not someone was traumatized, and more to do with the personality structure of this kind of person, where power is seen above everything else. And the moment someone disrespects that power, that person is going to try to get it back.
Yeah, well, it'll be interesting to see how he fares in a facility, a jail facility, where they lose essentially all power and control. That's got to be a mighty fall for the psychology of a person like that. Let's switch gears, Doc, a little bit. Jodi Arias just received a negative opinion from the Supreme Court, who refused to even really address the issues. You may know that earlier this year, the appeals court denied her appeal on the grounds that were being asserted for ineffective assistance to counsel, and that there were juror issues and the publicity tainted the trial. That appellate court basically rebuked those arguments, said she had confessed, that it's clear that she had planned this out before she went to kill the victim by traveling interstate, getting a rental car, shutting her phone, even though she had a car, shutting her phone off, carrying a weapon that she stole from her grandparents. So that's it as far as the appeals on the state level with regard to Jodi Arias. So what do you think about those developments? And again, I got to ask you, I love having you on the show. What is the psychological makeup of her? I mean, it was widely reported. I'm sure you know the case very well. You've had an opportunity to see the histrionics. Give me your thoughts.
Right. So sometimes it's about, especially when it comes to the state denying this appeal. Sometimes it's about the state doesn't want to hear anything more. Right. They've listened to everything, and the trial court has made a decision, and there's nothing left to say. The person had their day in court, and so the Supreme Court's not going to listen to any other kinds of appeals. So I'm not surprised that they rejected it without an explanation as to why they rejected it.
Yeah, that was the Supreme Court that didn't give an explanation, but the appellate court did. Yeah. And let's just real quick, Doc, let's just take a listen as to those thoughts.
The worst effect of the carnival-like atmosphere. It may still have continued, and you still would have seen the effect that this atmosphere had on, for instance, the witnesses who were being harassed and threatened, or the defense attorneys who were receiving death threats and were being followed from court to dinner at night and having their photos taken. The court doesn't have the ability to control what the public does, but they have the ability to control the things that are feeding the lynch mob mentality that was happening with the public. They can control whether or not the jury is impacted by that by sequestering the jury if it's necessary.
When we talk about the impact on the jury, Judge Stevens was quite careful to question them often about their exposure to the media, etc. And they all assured the judge that they could remain fair and impartial. When we look at what defense counsel did Judge Steven asked, do you want the cameras out of the courtroom? Defense counsel said no. There is one instance in over 60 days of the guilt phase of this where defense counsel said, yes, we'd like the cameras out of the courtroom. And the judge said, can you put that request in writing, which defense counsel did not do. So given that, how do we address the challenges you've brought up regarding the carnival-like atmosphere of this case that you've alleged in your briefing?
Well, separately and apart from asking for relief purely based on the publicity portion of the case, we're asking also that the court consider the way in which the prosecutor's behavior fed into and capitalized on that publicity.
If we consider the prosecutor's behavior in churning this publicity, don't we also have to look at Ms. Arias's engagement with the media? Because in my review of the record, it appears that she began courting the media.
After Ms. Arias was appointed counsel, I believe there was one interview that she gave, and that interview was on the day that she found out she was eligible for the death penalty. So, and she certainly wasn't standing on the courthouse steps signing autographs with fans or taking photos with fans.
No, she was giving an individual interview in a private interview session with members of the media.
And it's not to say that there isn't some consideration of that. Obviously there should be.
Counsel, you say some consideration. Didn't the defense approach the judge at one point and say that they were struggling because it appeared Ms. Arias was attempting to try her case in the media?
No, I don't remember that specific statement, but I take the court at your word that that's what. I just don't have a memory of that. But assuming that was true,
wasn't it pervasive at the start with Ms. Arias, getting out in front of the media as much as she could?
There were 3 interviews given, 2 of which were before she had counsel, and 1 of which was afterwards, and was the day that she found out she was eligible for the death penalty. So to say that Ms. Arias was the one that was courting the media, I don't know that I don't believe that the record supports that.
You know, Doc, that's never the kind of question you want to get when you're a defense attorney. That isn't before those appellate court judges. But I'm interested, again, from your perspective. I've been saying here at the Law and Crime Network, we have been covering cases gavel to gavel, as you know that we do it here, that these publicity stunts that go on and trying the case in the court of public opinion, I just don't understand why judges don't stop this from happening. And I only see it getting worse. So I want to know what your thoughts are about that. And secondarily, what effect does this pretrial publicity have on jurors, even the ones that say, I won't be affected by it?
Oh, yeah. Even the ones that say that they won't be affected by it will be affected by it. Some of them are just trying to hide what effect it had in order to serve on the jury. And so it's going to be real important that during the interview of the jurors process, you have a clear understanding of why the person is wanting to serve on a jury, whether it's the law and order sort of aspect of it, or whether it's because of the circus surrounding the crime. Obviously, despite a speedy trial, it does take a long time, and media does cover some of the more high profile cases. So there's obviously going to be residual information in a juror's sort of back of their mind, influencing why they're there. So it's real important that that defense attorneys and prosecutors have a clear understanding of why this specific person is wanting to sit on this specific jury, and sort of is the media influencing that willingness to participate?
That's really a fascinating perspective, because in all the cases I've tried, and I'm sure this is replicated throughout the country, the question asked of the jurors typically is, why don't you want to sit, on the jury? Most people are trying to get out of jury selection. What you are indicating, and I think you're probably right, is in cases like this, there may be a group of people that want to sit on the jury because they want to be in the middle of all that. So how does a judge ferret that out? Is it just as simple as a question of saying, why do you want to be on the jury? And 2, if that is the question, those people who are dying to get on that jury, do you expect that they would be telling the truth?
there's a whole field of psychology with trial consultation, which is a service that I do as well. It's a whole art in creating questions that ferret out why someone wants to do things. We all know that sitting on a jury, just any random jury, can be very difficult for a person to kind of get through. But if you know, right, as an attorney and as a judge, if you know that the case that you're hearing has already had a large amount of media exposure, you need to find out why someone would want to sit on this jury. And the answers that you hear from the potential jurors will provide a lot of insight. Some people will be able to indicate a true honesty and a true authenticity for the process of the legal system, while some people you can kind of tell are just either making up their answer as they go along, or it's been clear that they've been influenced and they either want to know they want to be the first to know, right? Something like that.
Very interesting, Doc. I really appreciate it. Well, we got a lot more on our plate here. Please join us on Facebook. Let us know your comments and your suggestions. I love reading those things when I can respond to them when I get off the show. So we're going to take a real quick break here at the Law and Crime Network, but we'll come back with another guest and more definitely very interesting stories. Stay with us, please. All right, this is something special that I want to do here on the Law and Crime Network, and thanks to the powers that be to allow us to do it. I think it's a very, very important topic, and that is the stress and anxiety that is occurring with regard to the election, as well as a combination of the election and COVID. I also have with us now our new guest for today, Ecleynne Mercy out of Atlanta, Georgia, criminal defense and personal injury at the Mercy Law Firm. She was a former indigent criminal defense attorney and trains legal observers when informing citizens about their rights as it relates vis-a-vis the police misconduct. Welcome to the show, Ecleynne. Good to have you back.
Thank you for having me. Thank you for having me.
Awesome. So I'm going to do this both from a professional standpoint first, and then I'm going to go to what your tips and suggestions are, Ecleynne. You know, Doc, there is considerable stress. The American Psychological Association estimates that 68% of adults say the election has been a significant source of stress in their lives. What are you seeing out there, and what are tips and suggestions to how we can deal with this insanity, for lack of a better expression?
First of all, I think that number is low. I think that number should probably be at 100%. I think everything that has gone on throughout the majority of this year has led to this point where, as we stand right now with razor thin margins on who's going to be the next president, this stress has been compounding time over time, from COVID to social justice and everything like that. It's going to be extremely important that not only does the person kind of disconnect from the news, but sometimes you might have to disconnect from people. It's going to be one of the bigger topics for people to discuss. So you might need an opportunity to just be by yourself, to unplug completely. And sometimes you might need a little lubrication to kind of help you, a little liquid, lubrication to kind of help you, and that's okay. Sometimes people need exercise, right? Sometimes you just want to feel like you want to break something, and it's okay to do that so long as it's your own stuff. So I think there are ways in which a person can manage their own anxiety symptoms, and it's going to get a lot worse over these next several days into the next year. I can imagine that people will have some pretty intense anxiety symptoms.
Yeah, I mean, listen, we're all up watching it. You could say don't watch it, at least for buffs like me, flipping around the channels, staying up late, not getting enough sleep, and all the trauma with it changing minute by minute is a bad thing. But you said like isolate a little bit, and that's probably a great strategy. But we're in a period where we've isolated for so long. It's just adding like insult to injury in my mind. But Doc, before I get to Ecleynne, can you give our viewers some idea of where they can go to find tips and suggestions on how they can get through this or help their family members out get through this? And when should somebody seek professional help?
The American Psychological Association does have a dedicated webpage to stress and anxiety. There are also state psychological organizations that you can go to that will have resources. And the moment when you wake up in the middle of the night because you had a nightmare about the election, or the moment that you find that you can't go to work, that you can't interact well with people because you're afraid of what you might talk about in terms of the election, once it starts directly impacting your life, that's when you need to seek help.
Excellent advice. Ecleynne, you know, as lawyers, we're amateur psychologists, or at least we think we are. What are your tips and suggestions? And what are you seeing out there with respect to your clients? Because I know these are issues that I'm hearing from my clients every day.
Yeah, it's unfortunate because what is happening is for the first time we're like seeing. I mean, I'm a Black person, and we have well been aware of white supremacy and just the impact of racism on the United States and its citizens. But for the first time, we have to really reckon with the effects of it, the benefits that people have garnered, the benefits that white people have garnered from, from slavery, from Jim Crow, from the school to prison pipeline, all of that, but also the negative impacts on people of color, on Black people, on top of COVID, on top of police brutality on every other day, on top of all of that. And as a person of color, as a Black woman, I can only speak for myself, and it's like we're always dealing with these things, but we also have to deal with the fact that we also have to deal with people who don't want to deal with it, who don't want to acknowledge that racism exists, who don't want to acknowledge that white supremacy is a problem, who don't want to acknowledge that this has been a systemic problem that we must deal with. And I think that the election kind of just although it's bittersweet because I do believe that we are going to be victorious. However, there's just a half of the population that racism isn't a deal breaker for them. And that's what we have to really acknowledge. That's what we really have to really just deal with. That racism isn't a big deal for half the population.
Yeah, well, I mean, Ecleynne, those are great points. Of course, there are multiple issues that voters are looking at, but I do agree with your point that waiting for them to break down that some people thought it would be a blowout one way or the other, but it's not. And it does speak as to what's important in the issues of people and who they think can deliver those things. Excellent points. Thank you so much for that. Listen, guys, switch gears a little bit here, guys. Former boxing champ Adrien Broner. Okay, so he was charged with assaulting a woman, and he was ordered to pay an $830,000 fine. He hasn't been paying those fines. They've been in court on multiple occasions. Recently on his Instagram feed, he wound up having all these piles of cash that he was showing off, and basically was telling the court, I only have $13 to my name. And I love this. I mean, there's not many statements you get from judges that can be memorable that will be in the record. But he went before the judge yet again, and the judge said, the jig is up. That's it. This is a contempt of the court. You're going to go to jail. So we're going to throw to a video from this Instagram account so that you could see for yourself how he put himself in jail.
All this motherfucking money, huh?
Bro, we world champions, man.
World champions.
Ocean
Deep.
Ocean deep.
Shit. Two-man team, huh? Fuck a three-man. This a two-man weave now.
All right, now he basically admitted that that money was his, as I understand, was given to him by friends who were supporting him. And he was indicating to the judge, I was using it to pay bills. Well, one of the bills he's got to pay is $830,000 to the victim. Doc, I got to ask you, what causes people to continually go on social media and either show that they're committing crimes? We did this as prosecutors. They literally would have their criminal activity on their website Is it just, again, they're not thinking, or is the desire to be seen overwhelming their ability to think?
It is the desire to be seen that is overwhelming their ability to think rationally as to what the consequences would be to actually post this stuff. He didn't think that it was going to be found out, or that it was going to be used against him, and it was more about just flashing the money that he had.
Yeah, and an attorney, these are your worst nightmares. Now, I was thinking when I was reading through this that the argument was going to be, look, this was a prop. It was given to me by friends so that I could do the video. It's really not my money, but that's not the way it worked out. And can you explain your thoughts about what he did, and also explain to the audience what a contempt of court charge is and how it does carry criminal consequences, including incarceration?
Okay, well, I am going to talk about. So here's what's happening. We are all in COVID conditions, and you have a prize fighter who has been on top at one point of his life, and is suffering from financial situations, and some people just need a win. And even if it's not a real win, some people need a win. Let me just. I think that the doctor will definitely agree with me, is that you self-medicate. And you don't have to self-medicate with just, drugs or alcohol. You can self-medicate with likes, self-medicate with retweets, self-medicate with reels and Snapchats and TikToks. And I think that a lot of our celebrities who are also feeling the strain, the psychological strain of, COVID and the election, just want to win. They want to feel better. You're looking at people trying to feel better. And with that being said, I did in the video, I don't believe he had an attorney, because I just saw him just talking off the hip. He didn't sound like he was prepared. I think that an attorney would really talk about his options, would really, talk about the fact pattern, what we are going to present to the judge. And I didn't think that he saw that. I believe that if he hires an attorney, maybe they can do some cleaning up, maybe a psychological evaluation would help in this case, so that we can understand where he was at when he posted that video.
Well, the judge had listened to multiple arguments he's made over a significant period of time. And as I said her legal reasoning for putting him in jail for the contempt charge was the jig was up. Guys, Whitey Bulger, you remember him, the mobster from Boston who was murdered in the Bureau of Prisons, in a federal prison? Well, now he's suing for his murder. We'll be right back. All right, mobster Whitey Bulger was killed in 2018 in the Hazleton Penitentiary in West Virginia with a sock with a padlock that was in it. He had received a life sentence for the murder of 11 people. He was an Irish-American gangster turned FBI informant, and gave the FBI lots of tips and data about Italians that were involved in organized crime that were his rivals. The suit says that the Bureau of Prisons failed to protect him by transferring him to Hazleton. He had been in 2 previous facilities in Arizona and Florida that specifically deal with high-profile and at-risk individuals, and they claim that this move to Hazleton, and let's be clear, federal government and the Bureau of Prisons often moves federal prisons serving life sentences to multiple facilities during that time. Within hours of being put in general population, inmates that were believed to have come from New England or the New England area are alleged to have killed him out of loyalties to their factions back in New England. They're suing for $200 million. And it's interesting because the lawsuit is filed on behalf of Whitey Bulger. In other words, he's kind of like the plaintiff in the suit, filed by a nephew who's acting as his executor, basically saying, I, Whitey Bulger, should be paid for my murder by the Bureau of Prisons. Okay, Ecleynne, let me start with you from the legal standpoint of things. What are your thoughts about the success and likelihood? They would have to show a breach of a duty of care. He was placed in general population. You deal a lot with law enforcement and their interaction with law enforcement and civilians. And within hours, he's dead. Is it a good lawsuit?
I actually think it is, and I think that it has the potential for setting precedents. I think that if you are a FBI informant and you are taking down whole criminal syndicates, it's foreseeable that that inmate needs more protection. You cannot treat him like another inmate. It's foreseeable. So putting him in that position, you literally, like, you signed his death warrant. So I think that, this lawsuit has some legs. I really do.
Yeah, so let me just follow up with that a little bit. And just to be clear, unlike a criminal case where you usually have to show either purposeful actions or knowledge that you're committing a crime, that does not have to be so for a civil suit. You mentioned the word foreseeability, which is part of the elements of negligence. And he is in the care and custody of the Bureau of Prisons. And so they even have a heightened duty for his protection. So I guess what you're saying is it would not have been unusual for them to know that a person who is or worked with the FBI with individuals who come from the very area that are in that same prison created that toxic scenario, and he should have been in a more protective custody scenario?
Yes, because you don't put snitches in gen pop. You do not put, people who have turned state's evidence in general population. You are signing their death warrant. And as an attorney, if I have a client that is like that, you have to be very specific. You have to make sure that they understand. You have to do conflict checks. It doesn't take that long to really run a check. Even back in the day, it didn't take that long to run a check to see if, hey, this are criminals that were affiliated with this type of case. Are they going to be here? Are they going to be in this place? Then maybe he shouldn't be in general population. Maybe he should be in protective custody. And I think that they failed. They basically, dropped the ball and kicked it when it came down to him. So I really think that this lawsuit is not only, I think it's necessary, to protect inmates who actually help the state. You can't get the conviction and then forget about the witness that got it for you. And I see that repeatedly. And until they need them again for like an appeal, or until they need them again for somebody else, they come and they provide some value, but without any protection. And it needs to stop. And I think that more cases like this need to be filed.
Yeah, it would be very interesting to see he move from two better facilities to protect him. He goes there, winds up in general population. Who made that decision and why is another interesting factor. Guys, we've got to switch gears. California versus Brandon Willie Martin, who's 27 years old, found guilty on all counts, and it's headed to the penalty phase for a death penalty. Now, it's out of California, and we know there's a moratorium on the death penalty put in place by the governor. Nevertheless, they're allowed to proceed forward with death penalty convictions. That will occur on November 9th, 2020. He is accused of killing Michael Martin, who is his father, 64 years of age, Ricky Lee Anderson, his uncle, who was 58 years of age, and an ADT security person that was actually putting an alarm system in the house at the time of the murder because of the family's concerns about harm that he would do to them. The incident happened on September 17, 2015. The defense is arguing in the penalty phase that drug abuse and psychotic episodes should keep him from getting the death penalty. He played for the minors in minor league baseball, but just before the murders occurred, he had decompensated to the point where he was put in a mental health facility. He was supposed to be in there for 3 days, but they let him out early. And the family members were very concerned because he had a lot of hateful speech towards his mother and his father, basically indicating that he was upset with his father because of his father's race, that being a black male. And then the mother begged them not to release him early. He was released early. And he came there and basically choked his mother, held her down, scissors to her neck, while saying he will never play baseball again as long as his parents were alive. So let me, Doc, go to this real quick clip of the prosecutor's closing argument in this scenario, in this case, which again, they received convictions on all counts.
That these men suffered multiple blows, and you can tell from the location of the blood spatter where this happened. And you know from that blood spatter that Ricky Anderson was hit when he was upright, and then when he fell to the floor, having been hit once or twice in his head. as he was 2 to 3 inches from that wood floor, the defendant hit him again and again. From Mr. Barry Swanson, you know, in that kitchen island, there are 2 distinct locations where there was blood spatter showing that he had been hit multiple times with that baseball bat. You'll see at the top of the island, there was one spot, and then another spot that was by the pantry door. And by that pantry door, we had blood spatter, and we also had on the side of the wall, the smearing, which is where Barry Swanson, having been beaten with that bat, was trying to gain some position where he could stand to his feet, and that's where you have that blood smear on the wall. And then with Michael Martin, sitting in that chair, waiting and waiting for the inevitable fact that he too is going to suffer a painful death at the hands of his own son. Multiple blows. And Dr. Schumann told you those multiple blows resulted in multiple fractures. And remember, these fractures, and you saw the photographs to the head, and you can ask for those skulls, which will give you a 3D understanding of the depression of the cracked cranium of these individuals. But to understand the force and duration, to understand the premeditation and deliberation, you can see that each one of these powerful blows from a professional ball player to the head, they're to the head, intent to kill. There's only one thing the defendant had in his mind at that time, was that he had weighed the consequences and considered his actions, and he decided to kill and then kill. And he did that by aiming at the head. You see, with Ricky Anderson had no defensive wounds. There were no strike marks to his body. He had no time to defend himself. The first strike was to the back of his head, just behind that left ear. And then he was struck in the throat. And as we just heard, as he went to the ground, he was struck again and again.
All right, so guys, let's talk this one out a little bit. Doc, I want to go to you first. Prior to this, horrific murder, this was the incident. Well, first of all, he was fired from the minors. He was being cut because allegedly he was using drugs, shouting and cursing. So there was erratic behavior well before this. A couple of days before this, as I indicated before, he's attempted to kill his mother 2 times on 2 separate occasions by choking her and holding scissors to her neck while making that statement I was saying before that he'll never play baseball again as long as his parents are alive. On September 15th of 2015, he's taken to that mental health facility and he's ordered out early. What are you seeing here with respect to the psychological condition? And can you do us a favor forensically and explain what that prosecutor was doing there? Was talking about premeditation, deliberation, that he was able to have the capacity to think, because the insanity defense requires that you prove certain things. Was this close to an insanity defense in your case?
Yeah, I think the defense did a real disservice to their client by not having a psychological evaluation for criminal responsibility in the insanity defense. So there's a difference between, does a person know what is legally wrong and then what is essentially kind of morally wrong, psychologically wrong. There's some real issues when it comes to someone being held on a 72-hour psychiatric hold, but then being released 1 day early. That's probably not enough time to stabilize on medications. And if he is still having lots of harm himself or other people, then he should have remained in the hospital. So I think there were a lot of issues that kind of fell by the wayside and led to this unfortunate incident happening, where this baseball player is not getting the psychiatric help that he needs. It could have been caused by the drug specifically, or it could be self-medicating because he has a much larger psychotic issue. But either way, he should have been treated better at the hospital. And the defense probably should have had him evaluated to determine whether or not he knew what was right from wrong when he was committing that act, because it's possible that he has this delusional idea that he can never play baseball again, which is why he ended up committing the crime that he committed, because in his mind, those two things are linked. They need to die, and I can play baseball again. And if that's the case, there's some serious psychological issues that should have been evaluated.
All right, well, we're going to have to leave that topic on the end. Like I said, folks, we'd love to see your comments on the Law and Crime Facebook page. We'll go through them and take a look, and if I can respond to some of them, I will. Unfortunately, the doctor is right. Many people are released from these scenarios prior to their medication being able to take effect and commit crimes. It's really an outrage in my mind. We're going to take a break. We'll be right back. All right, welcome back. We're with Brandon Willie Martin case, conviction on all counts, going to be headed towards the death penalty in California. Again, I can't state it enough. There is a moratorium on the death penalty in California. So we don't know where we're going with that. But the doctor was talking about the defense and what the defense presented. Let's listen to a little bit of their closing argument at trial to get a sense of where they were going.
Question number one, am I convinced beyond a reasonable doubt that Brandon Martin committed these acts? Number one, at the outset, there is no direct evidence that Brandon Martin committed these crimes. There are no witnesses. There is no statement from him saying he did it. Therefore, you must rely on the circumstantial evidence. And in order to do that, you must evaluate the circumstances surrounding these events. So let's do that. Number one, when you look at the circumstances surrounding these events, the first thing that jumps out to you is there is no physical evidence linking Brandon Martin to these crimes. Specifically, the murder weapon, the bat. There is nothing that puts that bat in Brandon Martin's hands on that day in September 2015. There are no fingerprints. There is no DNA. There is nothing linking Brandon Martin to that bat on that day. Second, when Brandon was arrested, his clothing, you can imagine it was processed. And what are they looking for? What would you look for? You don't have to be a forensic scientist. What would you look for after Brandon was arrested? Blood, right? You look to see, is there blood? Because we've all seen these crime scenes. We're all familiar with head injuries. What do head injuries do? They bleed. And if there's any question about that, the photos of the crime scenes answer that question. There's a significant amount of blood in that living room, in that kitchen area, and in that garage. Yet miraculously, none of it is on the clothing of Brandon Martin.
All right, welcome back. So the defense basically saying, Doc, that he didn't do it. I mean, it certainly is a good argument, and we call this the CIS effect a lot of times, where defense attorneys will try to argue like there wasn't that piece of dirt, and from that dirt, they were able to solve the crime. All these fantastical, arguments that get made on TV. They did it just by the old school way, circumstantial evidence. Obviously, the jury did not buy that argument by the defense, but I think you can expect, don't you think, Doc, that there will be psychiatric testimony in the penalty phase? Because that certainly would be a mitigating factor.
Oh, absolutely. I mean, like I said, it should have been done during the initial trial phase, but for sure during the penalty phase, there needs to be a psychological evaluation done, just so that the jury gets to hear kind of what was going on inside of his head and get him the treatment that he needs.
Yeah, Ecleynne, we have a short period of time, but give me your explanation as a defense lawyer, if you were going in there representing him in the penalty phase. I know you would have psychiatric testimony, but how would you construct the case to try to tell the jury, spare my client's life?
Well, I think, like the doctor said, he should have stayed in the psychiatric ward for as long as 72 hours, or at least he is stable. But I feel that it's more of a cultural thing. I have clients who look like him often, who go to the hospital, but because they present well and because they're Black, and a lot of the doctors don't understand how, different ideations happen for different people in different cultures, that he can really just skew and just be able to like present well and be able to be released. So you need to really, so I think that they really dropped the ball without filing.
I completely agree. I'm sorry to cut you off. There's a little bit of time, but I will make this note. This is California. Golden State Killer is getting a life sentence for 11 murders, and this gentleman is going on trial for his life. I just don't get it. Let me know your thoughts. I'm your host, Bob Bianchi. You can find me at rbianchiesq. I hope you have a great week. I'll be back next week.